I turn it over to Kevin, before I turn it over to Kevin, I just wanted to mention a couple of upcoming Turbo Talks that we have scheduled. One is on October 9th. That'll be at 1 p.m. And we're going to have Jim Thompson from IEDA talking about the Catalyst Grant and how to get ready to apply for that grant, which it opens in January of each year. And then on November 6th, also at 1 p.m., we are going to have a representative from the Iowa Arts Council talk about the funding that's available through their organization. So hope that if you're interested, that you'll join us for those. And you can find information about how to sign up on our Facebook page. Otherwise, with that, the only promise we have here is that we're going to wrap this up in 30 minutes or less. I know Kevin's presentation, he's telling me, is definitely shorter than 30 minutes. So we will have some time likely for question and answer if you guys have anything you'd like to toss Kevin's way. So with that, Kevin, I'll turn it over to you.
Okay, I will go ahead and share my screen here, hopefully. Everybody see the
Perfect.
screen now?
Yes, sir. Yes.
So, yes, my name is Kevin Olson. I've been practicing law since 1999. I've been working for cities in Iowa since 2000, and so I do have some experience with the Iowa open meetings and open records law. As you know, the legislature likes to tinker with the law because they like to show that they're tough on transparency, even though that those none of these laws actually apply to them. So they like to show that they're in for transparency purposes, except for their own purposes. They do not apply to or these do not apply to them. So the two big changes in House File 706 was passed in the 2025 session. There were two big changes to the open. It was mostly the open meetings laws. Number one, Section 21.6 enhanced the penalties and enforcement for illegally entering a closed session or violating any part of chapters 21 and 22. And then the second section here, which is the big one that everybody has been talking about, is the requirement set by the legislature that all the members of the governmental bodies who are new as of July 1st, 2025, must complete the course of education on chapters 21 and 22. I was going to say, if anybody has any questions, while I'm on a slide, go ahead and blurt those out. Otherwise, I'm happy to answer questions at the end and end of the presentation. So I'm going to briefly go through the changes to the penalty clauses here. So pre House File 706, the penalties were for each member where the judge could assess a penalty of between $100 and $500 for participating in a violation, and a penalty of between $1,000 and $5,000 for knowing participation in a violation of chapters 21 or 22. Yeah, I think the difference would be, we're going to go have a meeting somewhere else. It's got to be pretty blatant for you to have knowing participation. Sometimes people have meetings or something that they're not aware of. That would be the $100 to $500 penalty. However, to show that they are tough on transparency with local government. Post The new law says that the penalties that are enforced against the members now for participation in a violation would be between $500 and $2,500. And if you had a knowing violation, the penalty could be between $5,000 and $12,500. And do remember that if there is a penalty assessed against the members of the board, the governmental body cannot pay those um, penalties assessed against the members for violating chapter 21 or 22. So we need to make sure that our board members are well versed in these chapters, because it could cost them money. The city, if there are violations and they get sued, the city or governmental body loses. You have to pay attorney's fees for the people who brought the suit. So there are a lot of there are a lot of uh, financial ramifications for not following the open records and open meetings laws. I did bring this up. One of the things that one of the big things that people get in trouble with meetings are, I think everybody sort of understands that everything has to be in public, but what people get in trouble for is for having a closed session. As you know, in the code there's 20 some, or there's a lot of, in 22.7 there's a lot of ways to topics that you can talk to your members in closed session for. But if you over the years, there have been a lot of violations of stuff where closed sessions are illegally had, and that would be a violation of law. So one of the things that I always talk about as a city attorney, and I think I would tell my members this, there are defenses to to the members if they follow the guidelines here, that they can avoid having a penalty enforced against them if there is a violation. So I'll just read this quick. A member shall not be assessed damages if that member did any of the following: voted against going to a closed session. As you recall, that to go into a closed session, you need three-fourths of the members of the body to go into a closed session. So if you voted no to go into closed session, that would be a defense against having a penalty enforced against you. You had good reason to believe that you were going into closed session for a topic that was allowed, and that you followed all the requirements of the chapter. And the third one is, which I would always counsel my boards that I am part of. If you have closed sessions scheduled, what I would suggest everybody does is you ask your city attorney if they're there. Obviously, some cities don't have attorneys there all the time, but if there's a closed session, I would hope that you would have your attorney there, because a lot of the closed sessions talking about real estate talks about talking to your attorney for employment matters. You know, litigation, you should have your attorney there anyways. So what you should do before you have your vote on that is somebody should ask the attorney there and say, is this a valid reason, or we're going to closed session for this reason, X, Y, Z, whatever, and make the attorney put on the record that the attorney believes that this closed session is complies with the law, and that the members voting on it would not be face any damages if the attorney gave a wrong opinion and they went into closed session. Then that is a defense for any of the members to say, well, I was relying on advice of counsel, so why would I disagree with the counsel? So as a practice, I would always have your counsel, your bodies, ask the attorney if they're there, is this a valid reason for going into closed session? So that gives protection to the members. Obviously, most of the members of all our bodies are part-time people who are not well versed in, you know, experts in this area of the law. So as a practice, I would always ask the attorney to give an opinion, so that that can be placed in the minutes in case something else comes up in the future. The big thing that was adopted with House File 706 was the requirement that any newly elected or appointed public official who's a member of a governmental body shall complete a course of training of not less than 1 hour and not more than 2 hours regarding the responsibilities of the governmental body and the governmental body's members regarding Chapter 21, the Iowa Open Meetings Law, and Chapter 22, Iowa Public Records Law. So, this law went into effect on July 1st of 2025. The law allows that any persons holding their office or position as of June 30th, 2025 are exempt from having to obtain this training. So if you have, obviously, we're in the middle of election seasons for city councils, or those persons that are in office now are not required to go back and get the training to do this, to comply with this chapter of the law. So basically, what I would suggest everybody does is that you go back to your governmental body and you figure out. I think it's pretty easy to figure out which governmental bodies, you know, the city council. I'm just using the city because I use cities all the time. And you look in your ordinance book and you have a planning and zoning commission, a library board of trustees, a board of adjustment, or parks and rec commission, whatever commissions that you have created by ordinance. Those are subject to the open meetings laws. And then I would make a list of all your people who are on that board as of June 30th, 2025, to keep track of members that are exempt and members that, and then when those members are replaced, so that you have to know who needs the training and who does not need the training. So that is one thing I would do right away is that I would go back and get a listing of members and check off who needs the training, who doesn't need the training. So, how long do you have to obtain the required training pursuant to House File 706? Well, each newly elected or appointed official shall complete the training not later than the 90th day after one of these following events: takes the initial oath of office, and I'll skip the C, or is elected to office. So, as everybody knows here, if you have an election, you're elected and you're official after they do the canvass. And usually, you take the oath of, I can't remember what the date is, but you take the oath of office before you assume your responsibilities as a council member after the first of the year. So basically, what I would do is I would I would suggest, that you take the latest of the two of these election or the usually the oath of office, and you go 90 days from that date, and then so that those members need to complete the training within that 90-day period. So in and if you look at number or letter B here, that's talking about assumes responsibilities if not a member that's required to take an oath of office. I think that would be all the board members of planning, zoning, library board of trustees, stuff like that, where they're not really taking an oath. They're just assuming their responsibilities. So whenever they are seated at the first meeting, I would go 90 days from that to make sure that they have that training completed in that time frame. So, what type of training is required? So, the Iowa Public Information Board, if ever, I think most people are probably familiar with that. It was formed, I can't remember, 4 or 5 years ago. One of the iterations of it's codified in Chapter 23 of the Code of Iowa. And the Iowa Public Information Board is the agency that is tasked with enforcing Chapters 21 and 22 of the Code of Iowa. So, as part of this, IPIB was tasked with making sure that the training that it was outlined in the statute in House File 706 was completed, and so the Iowa Public Information Board has come up with some topics on each of these chapter 21 and 22. I'm just going to breeze through these. These are topics that have to be part of any training course. So basically, you look at these 10 items. These are items come up with from the Iowa Public Information Board. Most of you who have been in city government for a while know that pretty these aren't ideas that you have to go a deep dive into, case law or something to teach this. So this is not something this is just a rudimentary basic understanding of chapter 21. What is a governmental body? What is a meeting? So a meeting is a quorum of the members of the governmental body. So, you know, you can have there's a 5 member board and you have two people having a discussion with, a staff member. That is not a meeting under the public, under Iowa chapter 2021. Then it talks about how you give notice to the public when meetings are going to occur. Everybody knows that you need to give notice at least 24 hours in advance of a meeting. And the meeting agenda has to give the public appraise the public of the basic topics that are going to be discussed at that meeting. There have been lots of cases about how detailed that has to be, but basically, if you put an item on the agenda and say, we're going to talk about this project or whatever, that should be good enough to to meet the requirements of chapter 21. And like the last one, the closed session, you have to have 4/5 of the members of the body, or 3/4, sorry, of the members of the body. So if you have 5 member board, you have to have four members voting in favor of it. And remember, if members are absent, those are counted. You have to have 4 positive votes. So if there are 2 people absent from a 5 member board, you cannot go into a closed session because you cannot meet the requirements. The most votes you can have is 3. So go on to the next topic outlined by the Iowa Public Information Board. These are the topics that are required to be in the training for the Chapter 22 Public Records training. And so, you know, a lot of these items are talking about what is a record and how do you handle records requests from people. One of the things you have to remember to tell members is that pretty much everything that they create is going to be a public record. And in my cities, most of the cities have email addresses that are just for the council members. I always encourage our members to uh, use those email addresses when they are discussing city business. You cannot avoid having somebody look at a public record just because you're using your own personal cell phone or your personal email address, because those are public records under the law. So what you don't want to happen is you don't want to have a judge come and look going through your personal phone to go through everything on your personal phone to see if anything on there is a public record. So I would encourage people to make sure that they use their governmental issued email addresses for when discussing business. And if they're issued a cell phone for some reason, only use the cell phone or text when the city phone when you're doing city business, because you don't want to mix the private and public up, because, like I said, that's not a defense to producing a public record. So one of the things I will say, and I have worked with the Public Information Board. They're very helpful. So if you ever have any questions, always call it, calling the Public Information Board. They will work with you, give you an honest answer on what they think. They're not going to give you legal advice, but they will point you in the right direction, or point you to something that to make sure that you're trying to comply with the law. They get hundreds and hundreds of complaints for every year from residents of the state, and a lot of them are, I've talked to the first director, Margaret. She told me some stories of people who, a lot of the complaints filed, they have no basis, but they have to go through all those things. So anytime there is a anytime there is a public records request, the first thing I would do is acknowledge that you received a public records request from the person that said, don't just say, if somebody emails something in, don't just let it go. Acknowledge and say, I have received this, and we will get back to you as soon as we can produce the records. And if it's a voluminous request, you need to make sure that they they know that there might be costs involved here. I'm not going to get into the details of, that's one of the things we have to, the training will show, but there's a bunch of new rules or best practices about what people should be charged for asking for public records. And the one last thing I will say about public records, you cannot ask people why they want the public record. That really is not something that you're supposed to be asking there. So any citizen has the right to ask for a record to see if it is available. One thing you do not have to do is you do not have to create a record that meets what they are looking for. I mean, I think everybody's probably gotten these surveys from people asking about, I want to see your employee list. I want to see by, their title, and how much of it, what they're paid, this, and I want it all in one sheet. You don't have to create a record to comply with what they were asking for. Um, so that would be so like I said, most of the time the city clerk will handle that and will delegate that off to whatever department head that would be the person that handles the record. So as a general rule, you're supposed to respond within 10 days of receiving the public records request. There are some that you just can't do that, but make sure you're talking to these individuals. If you're going to run over, just say, "Hey, I'm trying to run over. I'm going to run over a little bit." The worst thing you can do is just ignore them. Then they'll go file a public records request, and then Public Information Board will start making inquiries, and that's not what we want to. That's not what we want to have done. Not that the Public Information Board is a scary agency to talk to, but it's just more work that you have to do that you could have just covered by, communication with the person making the request.
And if I could jump in here,
Sure.
Kevin, we had a question from Taylor that we were intending to discuss anyway, which is basically, so you're telling us there's this training requirement. How do we get
Yep.
trained?
Right.
If I've got that right, Taylor. Um, and so basically, you have to be trained by somebody authorized to do the training. The Iowa Public Information Board is offering training for free. It's virtual training, and you can go to their website and sign up for that training. Um, right now, there are other entities that are in the process of getting authorized to be able to do this training. We know that the School Board Association, I think, has become authorized. I know Lynn County, I don't know if we have any Lynn County cities on here, but Lynn County is authorized, and they're opening their training to anybody that in Lynn County that wants to attend that. Um, I've heard that the Library Association is looking at providing training for free. I believe that will also be virtual training. Here at ECOG, we are actually hoping to partner with Kevin and also get certified to be able to conduct the training, and in particular to be able to do some on-site training, because we know that sometimes members of city councils, park boards, landfill commissions, whatever, members are just not always comfortable doing it in an online environment. Those are a few resources that we know of, and the Iowa Public Information Board um, has information on their website as well. I should also say that Iowa State is doing the training, but I think it's like a $50 fee, and I think that's also online.
Yeah. All right. I'm just going to keep going here since we're talked too long already. It's funny a lawyer would talk too long. What is once your members are trained, what is the requirement of the governmental body to ensure that they have records proving that their members have been trained? So basically, as Karen suggested, IPIB, along with all these other entities, are who are becoming authorized or certified trainers to comply with House File 706, are required to present a certificate of completion. And there's some requirements of what has to be on that. But the people training have to require each member who has gone through the training with a certificate of completion of the training. So House File 706 requires that the governmental bodies uh, maintain records of the trainings that are taken by their members. So if you have a member who gets trained and they get a certificate of completion from the trainer, I would suggest that everybody, the city, the county, whoever, whatever board entity you represent, I would get a copy of that and make sure that you have that on file, as the law requires that if somebody asks for a public records request about who's been trained and who hasn't been trained, you can just pull it up and say, okay, all these members who are new after July 1st of 2025, these members have all been trained. Here's their certificate of completion that is required from the trainer. So it's easy to prove that your people have been through a authorized course to comply with House File 706. So I would suggest once again that once you have your list of people on your boards, that you keep these and you make sure that you obtain the certificates of completion. I'm sure if your member doesn't get it, or forgets or doesn't know where they put it, I'm sure you can contact the trainer and obtain a copy of that certificate that you can keep on file with your individual. So it's pretty easy. Just make sure that you do that as people are trained. It also helps you to ensure um, that your members are following the law. I know people are going to moan and groan about having to spend another 1 to 2 hours looking at this stuff when most of these people aren't getting paid to do any of this, just doing this out of the goodness of their hearts. But you want to make sure that the people are trained and that they have proof of that, so that there are not fines. As you go back to the first slide we talked about, fines could be between $500 and $12,500 for not complying with Chapter 21 and 22. And this training requirement is now codified in section 21.12 of the Code of Iowa. So I suggest that, especially right away, my guess is you're gonna have newspaper entities or people who public interest groups who will ask for this information to ensure that that training has been encouraged. So
Kevin, we had a couple of questions that are related
yeah.
here. Do reappointed members, would they need to get trained?
No, I was looking at the Public Information Board. Just if they are reappointed to the same position, they do not have to be trained. If they are reappointed to a different position, I don't know what that would be. Sometimes you will have to get trained, but as a general rule, if you're reappointed and somebody's been on the board for 20 years, which just getting board members is hard enough. So, in my understanding, looking through the training materials with IPIB, is that they do not have to be trained if they are just reappointed to the same position.
And would the same apply if you were reelected with no break in service?
Correct. If you, there's question in my mind if you went from a mayor to a council member or a council member to a mayor, whether you'd have to have the training again. But if you are reelected as a council member, it is my understanding that you do not, and you are already in place, anybody who's an incumbent who gets reelected, you do not have to obtain the training. So just
And
because there's an election that comes up, you don't have to do that.
and what if there was a break in service?
If there is a
Meaning,
break in service, I believe I read some of the public. I'm going to reference some public information board advisory opinions at the end of this. I believe it says that if there's a break in service, they will have to get the training back.
yeah. All right, 2 minutes.
2 minutes. I'm thinking about done anyway. So here's just the failure to complete the training. I kind of talked about this. In theory, the public information board could issue a 60-day notice of deficiency that says you haven't been trained, and if you don't complete the training within the time frame, that I think the public information board could bring a case against you for not filing that. But I hopefully we don't get to that point. I think it's pretty new here that hopefully everybody gets trained all at once. So basically, as I just referenced here, there's some advisory opinions. The Iowa Public Information Board issues advisory. Their board issues advisory opinions regarding all sorts of topics that apply to Chapter 21 and 22. I just listed these two advisory opinions that have some of these exact same questions that were asked earlier about training requirements, and so I think it would be good if you have questions in the meantime before you train. This would be something that is pretty helpful to look at. And does answer a bunch of questions regarding, the detail of, everybody has to be trained, but like you said, there's all sorts of situations where, people aren't going to have to be retrained or they don't, their position doesn't a requirement. So like city clerks, city attorneys, superintendents, none of those people have to be trained under public, or even though they're integral parts of your public information or your governmental bodies, they do not have to be trained. It's just the members of the boards. So anybody else have any other questions that I haven't covered? And like I said, I can, my email is probably on there, but I'm, I am trying to assist, as Karen said, with getting a training regiment together. So I will be doing a more detailed dive on all these topics too. So if anybody has any questions, feel free to reach out to me. Karen has my
Um,
email.
Mitzi, we will put the recording out on our website, EasyCog website. But if anyone's interested in just getting the PowerPoint, why don't you let us know and we can send that out. Um,
I
yeah.
apologize in advance for my rudimentary PowerPoint skills. I have none. So
So I'd say at this point, spread the word. If there are people that you're aware of that are unaware of this change in the law, please let them know, and we'll probably have our webinar posted within 24 hours. So,
and remember that when it affect July 1st, so if you had changeovers in board, people who just moved out of town or whatever, some of these people might have already have to have been trained by now or getting close to the end of their 90-day period. So, uh, like I said, I do encourage everybody to get a list of people together from June 30th to make sure that you're keeping track of that.
right, and just based on last thing before we wrap up, just based on the feedback, we'll send the PowerPoint out to everyone, so you'll get
Okay.
that.
All right.
All
Well,
right,
thank you
thank you,
very much.
everyone. We
Thank
appreciate
you.
you joining us today.
Bye.